Hey there! Welcome to our discussion on a crucial aspect of property management, the eviction process in Oregon. This procedure carries significant legal implications for both landlords and tenants, making understanding it essential. Let's dive into this topic to get the knowledge necessary for effective and responsible property management. Evictions vary from county to county, but they still follow the same general eviction process. Send a notice, fill out the forms, serve the tenant, attend the trial, and wait for judgment. Landlord-tenant eviction proceedings are dependent on the agreement signed by the tenant and the landlord. An eviction process is usually the last resort when it comes to evicting a tenant. Landlords are advised to seek the services of a mediator. These services can save them hundreds of dollars in fees. This video is a summary for a landlord to refer to when filing an eviction. Get the guide to eviction laws on the go from DoorLoop's Landlord's Guide series. Click the link in the description to get all of our best tips. Please don't hesitate to contact a legal professional if you have any questions. Now, let's dive in. Eviction reasons. Failure to comply with rent deadlines. To pay rent within the deadlines is a requirement. Rent is usually considered late a day after the rent is due. A grace period may be available if stated in the lease agreement. Tenants or renters should pay the rent on time to avoid getting an eviction notice. Non-payment of rent is a common reason for an eviction case. Oregon considers non-payment of rent on the 4th day from the rental period as late. Before a landlord may start the eviction process, they are required to give the tenant an official written eviction notice. Providing an eviction notice is crucial to the process. The notice to receive may vary depending on the tenancy type. If rent is paid within the notice period, then the landlord cannot continue filing for eviction. In the event of continued non-payment, the landlord can continue filing for an eviction lawsuit. Violation of the lease. The rental agreement has to be upheld by both parties for the entire duration of their stay. Landlord-tenant agreements may vary from tenant to tenant. If a renter has violated an agreement, the landlord may issue a 30-day notice to comply. The time period can give the tenant a chance to correct their violation within 14 days. If a tenant resolves their violation on time, the filing process does not continue. If not, the tenant has the reminder of the 30 days to vacate the property. Oregon lease violations may include damage to the rental unit, several unauthorized people living in the property, and keeping pets in pet-free properties, etc. For weekly tenants, the landlord must provide a 7-day notice to comply. The notice period allows 4 days for the tenants to correct these issues. The landlord prioritizes the health and safety conditions of their tenants. Anything that affects the health and safety of the tenant negatively is considered a violation. Health or safety violations also include not throwing out the trash for long periods of time, damaging the unit's electric lines, and inviting rodents in the rental unit. If the violation is not resolved or the tenant remains at the rental unit, then the landlord can continue with the filing. Conducting illegal activity. In order to evict a tenant conducting illegal activity within the property, the landlord needs to issue an official written 24-hour notice to quit. Some examples of illegal activities Oregon recognizes are prostitution, involvement in the creation, distribution, or consumption of a controlled substance, manufacturing a cannabinoid extract without a license, biased crimes, burglary or theft, and threatens or inflicts injuries on others on the property. The landlord is advised to keep a close eye on their tenants to make sure illegal activity does not go unnoticed. Any information is valid. Providing false information. A tenant in Oregon can be evicted when they provide false information in their rental application. Information such as the tenant's history as a convicted criminal and wrong contact information. Oregon landlords must give 24 hours notice before filing for an eviction action. Damages from owning a pet. The landlord will issue a 10-day notice to the tenant to rehome their pets. Should the tenants prove unable to do so, the landlord can continue filing a complaint. Non-renewal of the lease after the rental period ends. According to Oregon law, the landlord must not evict a tenant or force them to vacate the property without probable cause. As long as the tenant does not commit a violation, they can stay until their lease period ends. There are times when a landlord may not want to renew their tenant's lease. In this case, Oregon eviction notices and notice periods about non-renewal of the lease depend on the tenancy type. These notices can either be a 10-day notice to quit or a 30-day notice to quit. A landlord may terminate a month-to-month tenancy without cause only during the first year of the tenant living in the property. After 1 year, should the tenant stay after their agreement ends, the landlord may continue with the process. If you want your own Oregon lease agreement, head over to DoorLoop's forms page to download your very own template. Click the link in the description to learn more. The reason for evictions must always be valid. A landlord cannot evict a tenant without cause. The eviction notice must include the reason for eviction and the length of time before a tenant has to face a lawsuit. The information found in the landlord-tenant rental agreement helps greatly when it comes to determining what the tenant has done wrong. Filing a legal complaint. How to file a complaint. The eviction action process can only begin after the issuance of the appropriate written notice. Enough time for the notice must have been allowed before filing for an eviction lawsuit. The process is as follows. Proceed to the justice court the rental unit belongs to, file a complaint, and pay the fees. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template, or create your Oregon eviction notice by clicking the link in the description. To use a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want to do is go to court only to find out you did the first process incorrectly. Serving the tenant. How to serve a tenant. An official appointed by the court delivers the summons for the hearing and the complaint to the tenant. The court's clerk or the professional process server is usually assigned this task. There are several methods available. Personal service. The professional process server delivers the summons and the complaint to the tenant personally. Mailing. The clerk mails the documents via first class and certified mail. Posting. The professional process server posts the documents on the entrance to the tenant's rental property. After serving the summons and complaint, tenants have at least 7 days before the first appearance hearing to prepare. If the landlord and the tenant attend an appearance hearing, the eviction hearing should follow within 15 days. Timeline. The documents should be served to the tenant 7 days before the acceptance hearing is scheduled. A tenant may request a continuance for a maximum of 2 days. These apply only to the eviction hearing. If you want to learn more about Oregon's landlord-tenant laws, click the link in the description. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. The landlord must provide a strong argument backed up by solid evidence against the tenant. Should the tenant fail to show up to the hearing, the landlord wins by default. The tenant must move out within 4 days before the writ issuance. Next procedure if the tenant disagreed and replied. In the state of Oregon, before an eviction hearing is scheduled, both the landlord and the tenant must first attend the appearance hearing. If the tenant appears, a written answer must be filed by the first appearance hearing. The landlord must give evidence or information and show it during the hearing. This could include, but is not limited to, the following: copy of the deed and lease of the rent, rent receipts and ledgers, information on bank statements, and photo and video documentation. If the landlord wins the case, writ of execution will be issued and the eviction process will continue. Move out process. In Oregon, after judgment is passed in favor of the landlord, renters have to move out immediately once the law enforcement officers execute the writ. Only the appropriate authorities are allowed to remove the tenant by forcible entry. Should the landlord win in court, they are not allowed to undertake any illegal methods of eviction. The state of Oregon does not specify what to do with the tenant's belongings. If any belongings are left behind, landlords are advised to contact them and give them a reasonable time frame to claim them. After the time frame has passed, their property may be sold or disposed of. Timeline. The tenant must vacate immediately upon receiving the writ of execution. If not, the officers will forcibly evict them from the premises. Oregon eviction process timeline. Here's the average timeline for a complete eviction process. This timeline does not include special cases or activities such as requests for an appeal or continuance. On average, it would take anywhere between 1 to 2 months for a complete eviction process. Showing evidence. How to keep good records. If the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge and win your case. This part is essential to your case as it provides the courts with the evidence to decide in your favor. You can stay organized by keeping a physical trail. This is very hard to search through, takes a lot of storage space, and could get lost, damaged, stolen, or burnt in a fire. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable. PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is used best when you also scan every document into your software. DoorLoop is a great example. You should check it out. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, showing the terms of the agreement, when rent is due, and any penalties for late payment. All payments, showing all previous payments, how they were normally made, check, credit card, ACH, etc., and what date they were normally paid on. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also show any fees your bank may have charged you and any penalties you are owed according to your lease agreement, and all messages. If you sent your tenant automated or manual payment reminders by text, email, a letter, or mail, it's important to show this. While it's usually not needed, it's still good to show that they were aware of the situation and were given time to cure and make payment. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you're evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's safe to say you will normally win this dispute. Video. If you didn't catch them in the act, a video of the damages or the violation could also be enough. Pictures. They say a picture is worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. And lease terms. Once again, show the court which term they violated in their lease agreement. Don't worry if it doesn't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. And that wraps up our deep dive into the eviction process in Oregon. Whether you're a landlord or tenant, remember that understanding this process is vital. As always, please like, comment, and subscribe for more property management content. Also, check out these videos. Thank you for joining, and until next time.